So who controls the business and for how long? The first scenario I wanted to deal with was a situation where you have an active parent along with children. The second one is siblings with no active parent involvement. And the third would be the possibility of family members who are shareholders but are not active in the business. So if we deal firstly with active parents, it's reasonable and beneficial that the shareholder agreement provide for a timetable for the retirement of a parent or the senior decision maker to allow for an orderly transition of control to the next generation. As parents get older, they may lose some of their effectiveness, and hanging on too long after that may have an adverse effect on the business. You will still want to provide for the continued participation of the parent to accommodate transition of customers, contracts, employees, because the parent will have a long and valuable corporate memory. In many cases, even after a transfer of control, the parent may retain a significant financial interest, and that needs to be protected at the same time. This is a very delicate situation and needs to be addressed carefully to ensure that the parent doesn't feel that they're being pushed out of the business, but should form part of the agreement. To highlight this, I was involved with a father and son who had very different ideas about the timetable for Dad's retirement. So different, in fact, that after much discussion and arguments, the son actually left the business. A couple of years after that, the father sold the business to a third party. Unfortunately, the business thrives and the son struggles, and perhaps that's not unfortunate for the third party who purchased the business. But because the father and son could not agree on a timetable, the son left the business and now is having his own financial struggles. So you also need to remember that turning over voting control is usually much less important than handing over the day-to-day control of the business. Transfer of control can be achieved in many different methods and can be dealt with in the agreement. And when we speak of transition, we may be talking about transition of management versus ownership, and we usually see the transfer of management in advance of the transfer of ownership. Mom and Dad may transfer or hand over the day-to-day management of the business to son and daughter long before they actually transfer the ownership. So that's active parent. The next scenario is siblings. When siblings are in control, the situation can be somewhat more complicated than two strangers. As I mentioned before, strangers will not necessarily be having Sunday night dinner at Mom and Dad's. So not only will they potentially have business problems, but that may also affect their family relationships. In the scenario where we have control of the business or operation of the business by siblings, a mediation mechanism is recommended with someone who specializes in and understands family business and the issues inherent in that family business. The agreement also needs a mechanism to deal with the fact that mediation may fail. So if after exhausting all reasonable efforts to deal with the disputes, the siblings cannot come to a resolution, then you need to have some sort of an exit strategy, such as a shotgun buy-sell or a mandatory binding arbitration, or both, with arbitration being required before exercising the buy-sell. I'll talk a little bit about buy-sells a bit later. You also have to decide how the control will be exercised, so either by way of a majority or by way of unanimity. There are pros and cons to both. Do you want to have a casting vote or a status quo? 50-50 owners usually run the risk of not advancing the business. If we have the unanimous requirement and you and I, who are 50-50, don't agree, then we don't move ahead. Whatever proposal I make that you don't vote for, we simply don't do, and vice versa. So this may cause the business not to advance, and having a casting vote can deal with this. But it's also quite divisive, and it comes down to a business philosophy. Are we partners in this business, equal partners, or is this your show because you have the casting vote? clearly some significant thought has to be put into that before you decide on a casting vote. Now, quickly though, I want to just mention that if you do provide for a casting vote, you do need to consider the impact on the definition of a private corporation and whether it's a CCPC, a Canadian-controlled private corporation, as well as eligibility for certain reserves, capital, non-capital losses, liabilities for Part 4 tax. I can't deal with these issues today, but they do need to be considered with your business advisors, and by that I mean legal, tax, and accounting. So those are issues that should be addressed at the time of determining how control will be exercised. So the next scenario is an active and non-active shareholders. This really can be the most significant or the most difficult situation that we come up with, and drafting an agreement in this scenario can be quite challenging. Again, I don't want you to all remember in the back of your minds about the conflict of interest and who does the lawyer who's drafting the agreement represent. So in the situation where you have active and inactive shareholders, the family members who are not active will usually not be concerned with the day-to-day operation of the business, and they may treat the ownership of those shares in that business as any other type of investment that they may have, or alternatively, they may demand a very high level of accountability and may expect high levels of benefits. I expect that whichever one that is will depend on how mom and dad ran things when they were in charge before siblings or active and non-active shareholders got involved in the business. So conflicts can arise because the non-active shareholders view that the active shareholders are treating the business as their own, using it for their own private advantage, such as meals, car leases, and at the extreme, repairs to the cottage. So a shareholders agreement can contain conditions that recognize the differences by dealing with provisions with respect to rate of return. What are we expected to receive as a return? It can also allow for the inactive shareholders to rectify matters if they don't get their due. So it can specifically provide contractual rights to the non-active or inactive shareholders to enforce certain rights. There may need to be a method, or we can include a method of cashing out, such as a drag-along right. And for those of you that are not familiar with that, if I am a majority shareholder and I run the business and you are a minority non-active shareholder, if I want to sell the shares, my shares of the corporation, we can include a provision that requires me to sell your shares at the same time. So I can't sell my shares independent of yours, and that provides you with some protection that you don't get left with someone who I sell to that isn't as capable or isn't as kindly as I might have been to you. So that's what a drag-along right is. The agreement can also create negative covenants, so that it can impose limitations on the active shareholders. It can limit expenditures, it can limit salaries, and the like. And it can also provide for reasonable compensation for the active shareholders, so the non-active shareholders don't feel like they're getting ripped off. Now, other issues that arise where there are active and non-active shareholders will include whether or not the active shareholders will own voting or non-voting shares. And even if they are voting, will there be situations where they can vote where there's a fundamental change to the business or a change to the share rights of a non-active shareholder? So these things can be dealt with both in the articles with respect to the share provisions, but they can also be dealt with in a shareholders agreement. So I may not have, I may be an inactive shareholder and I may have non-voting shares, but if the active shareholders are going to be doing something that will fundamentally change the business, then I will have the right to vote and impact on that decision, even though I don't have non-voting shares. Now, another fundamental issue is whether or not active family members should have any shares at all. So if I'm not active in the business, maybe I don't get shares of the corporation. Now, there are pros and cons to that, but I recently worked with a client that had a business that represented about 90% of the value of his estate. He had 3 children, one of which worked in the business for many years, the other 2 did not. And then the son in the business basically thought that the business was his. In this case, what does Dad do for the son in the business? The kid's not in the business, and at the same time balance the potential inequity when Dad dies. Now, we happen to be in a position where we were able to use life insurance to narrow the gap, but Dad did not exclude the non-active kids from ownership of the business when he made the ownership transition and dealt with value on his death in the agreement. So there are ways to deal with this type of situation in a shareholders agreement. Now, I mentioned before that one of the ways to protect the non-active shareholders is to provide for rights within the shareholders agreement. But I think we have to also remember that even where non-active shareholders have no contractual rights, the various Business Corporations Act grant the shareholders oppression remedies. These oppression remedies are very broad and comprehensive. They have the right to challenge the company, the board, when there is conduct by the shareholders that's aggressive or unfairly prejudicial to the non-active shareholders. So whether or not there are contractual rights or not, the non-active shareholders still do have very significant comprehensive rights under the Business Corporation Act that created the corporation. So those are the 3 scenarios under who controls the corporation.